parties will have 15 minutes in which to argue their case. If the appellant wish to retain up to 5 minutes for rebuttal, let me know now, and I'll keep track of the clock and let me keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain by the podium as much as possible. We have read your briefs and we're ready to proceed with them.
Yes, may it please the court. Counsel, I would like to reserve 5 minutes for rebuttal. Thank you. On behalf of Nancy Hoffman, the appellant, I'm not here to waste everybody's time. I ask that you please distinguish this case from normal cases as to whether or not a trial court can sentence somebody to 180 days. That's not what I'm appealing to. And I ask that you just please be patient with me so I can at least explain how I got to where I got and why I'm here. When I grew up, we were real poor, and we had a Commodore 64 that the family used. And the reason why that's important is because it didn't have a hard drive built in. And we weren't rich enough to buy a tape player to record anything I used to type up. So I used to, during school, write up a program on pencil and paper, and then at night I'd go home and I'd type it all up, and I'd hit run. Now the big deal with that is, if I hit run and I was missing a comma, or if I told this code to go somewhere that didn't exist, it would crash. And then I'd spend all the next day in school and try and figure out on pencil and paper what was missing. The reason why I give you that as background is when I looked at the statute for sentencing, there's certain things that a trial court can do and can't do. We are all, as we sit here, creatures of statute. I exist under revised code. So do you. So does the trial court. The trial court acts under Constitution and revised code. So when I looked at the revised code in this case, there's certain things that a trial court can do. I took time and also read Appellee's brief, and I took review of some of the case law I had in there, and I took a look at their position. Nancy is not arguing that a trial court cannot sentence her to 180 days for what she was convicted of. But Nancy is saying that what a trial court is allowed to do is only what the code section allows it. In determining the appropriate sentence for a misdemeanor, the court, quote, shall consider all of the following. It does not say, as I'm sure the prosecutor would like to say, plus whatever other factors, that arbitrary thing we want to throw in as a trial court, a sentencing. The reason why I bring that up is after we entered a plea and we went in for sentencing, Nancy had done a PSI. The PSI is forwarded to the trial court. The trial court then reviews the PSI, as everybody here knows.
Is the trial court in the record here at the Court of Appeals?
The PSI has been filed and is on record with you guys. We did get an order for that. And I did also get the transcript from the hearing, and that was also filed. So as to any argument by appellee that the record's devoid as to any factors of the sentencing is there. What was discussed is there. The factors that went over for sentencing were there. What made my eyes open up more of a deer in headlights based on my 20 years of doing this is when the trial court then at sentencing says, I get all that, but you know, I spoke at your client's daughter's school, and I warned them all that if they do this, I'm going to get them. At that point in time, the trial court added factors that were not under 29 point whatever I cited in the brief. He now started becoming this arbitrary person that how can I, as a trial lawyer, have ever prepared myself, my client, then I could have brought in whatever he had said at the school. There's things I could have done as a lawyer. What he brought in was this thing that's not stuck by 2929 under Ohio Revised Code. He brought in this whole other arbitrary thing that to me was an abuse of his discretion. It did not allow me or Nancy any opportunity at all to be able to ever prepare that. Who could have ever said that her daughter was even there at that moment when he spoke to the school? Who's to say that she then went and told Nancy this stuff so that we can then say, okay, yeah, Nancy, you were warned of that. I can see why the trial court used that. He said that to you. That's something you should have known. We should have been ready for it. We could have prepared for it. There's no way on this earth that this code section allows that trial court to do that. It doesn't allow them to say any plus wording that they want to add. There are factors, and I went through it as I would when I was programming, and it says in there, in determining the appropriate sentence for a misdemeanor, the court, quote, shall, quote, consider all of the following. The nature of offense, whether and I went through all of them. No military service. At sentencing, I went through all those factors and expressed all of the positive things that Nancy had had. The prosecutor presented absolutely nothing of devoid on the record on their position and would say, hey, that Nancy somehow messed up here, messed up there, here's the other factors you should use against her. So nowhere on that record is that. The trial court then on his own says, well, you know what, I'm going to make as a witness a statement that I warned your daughter and then I'm gonna make, as a lawyer, no objection to it, and then I'm gonna then sit there as a trial judge and make a finding that I'm gonna use that against you now. Which is what our second argument in the assignment of error 2 is. This trial court, by doing that, is basically doing judicial fact finding. He did all that on the record, and there's nowhere for me to fight it. I did say to him, Your Honor, here are the factors, but there's only so far that I want to push a trial court. I don't want to start saying, well, you know, I think you lost your mind or anything like that. I can only, under a lawyer zealous who represents my client up to a point, and I did here, in trying to point out all the positive things she had done. Nowhere on the record was anything negative other than the PSI. Now, if he says, well, you know, in the PSI, these are the factors that bother me, then I can rebut that as a lawyer. But nowhere does he say, hey, you know what? In the PSI, it says she's not a plain white dove, and she had this past of this DUI or whatever she had years ago. Nowhere does he bring any of that up. He says, I warned your daughter at school, and I'm going to use it against you. So that's why we have an issue with it. There was no way I could have ever prepared for that as a lawyer. There's no way Nancy could have prepared for it. Nancy didn't mess up since then. Now, the reason why
Counsel, before you proceed, but the prior, how many DUIs were there?
I believe there was one alcohol-related offense, which was a traffic offense, which was the DUI.
Okay, because I'll ask counsel on the other side, because I thought they mentioned 2 or 3.
Yeah, they said 2 or 3, but you know, we looked at the PSI, and that's what stuck out to me too. After we had filed it, was that.
I apologize for interrupting you.
Well, you could have interrupted me.
No.
Your job. I told my client, get ready to drill me, because they can send you up to 180 days normally. But my issue was under the code here, where does it say that he can bring this other thing in? It said you can only consider the nature of the offense, the circumstances, regarding the offender, the vicinity, youth, age, disability, is likely to commit future offenses, and that's what I prepared for, and that's what I put on the record.
Is it possible that, I mean, if you're reading section B1C, offender's history, character, and condition of the PSI would have at least fallen into that category, so.
What is her
Is
history,
there
Your
a
Honor?
harm? I mean,
What is her history of her daughter having
I'm
been in
just saying,
school?
whatever's in the PSI, which I haven't read yet. but-
Nowhere does it talk about that her daughter was warned in the PSI. This is the trial court at sentencing saying arbitrarily and unreasonably out of nowhere, hey, guess what, I warned kids at school, and I'm gonna get you for it. And that was my issue with it. The other part where if the trial court then abuses discretion, then any order you then issues de novo. So there's Nancy, there's her daughter, she hasn't committed any new offenses. We ask that those 7 days be held in abeyance if she commits a new offense or in any way violates any other order of the court. She's complying with everything they want, she's doing everything they want, she hasn't messed up, she didn't mess up during any time before that. In fact, when you look at the appellee's brief, they agree under their argument of law that according to 2929.22, the trial court must consider the criteria listed. They even agree, they say must. The code section says shall. So when I write a code on Commodore 64, those are not discretionary. They have to do that.
But there's no court that has said that you have to do it on the record or that it has to be in the entry.
I'm not saying it doesn't have to be on the record. I'm saying when you do it, you better just follow these. What gives you the right to then add this arbitrary thing out of nowhere and then use that as a reason? And that's on the record that he said that. So it's not that the record's devoid of it. It exists for you guys to review it. He said it. It came out of his mouth. He moved his muscles out of the whole world. He didn't talk about pink elephants. He says, your daughter at school, I warned her, so guess what? I'm going to teach them a lesson. How's that Nancy's? Nowhere in the record did anybody say she found that out, that anything was said to her, which then as me as a trial lawyer, I can't prepare for that. I can't prepare for the factors and get ready for them, and then he can then use those against me. And nowhere in the factors that say any other reason or any other stuff is limited and capped. So that code that they want is open-ended. The code that's written is closed.
So you're saying the trial judge chose to use that circumstance almost as, for lack of a better word, an aggravating circumstance in sentencing, right? I warned your daughter, shame on you.
But how can I prepare for that circumstance, Your Honor? I don't even
Or even know whether it happened.
at all, or that anybody testified to it. And then the state, in their position in sentencing, don't say one bad word about Nancy. They remain silent. They could have. They didn't say one word. The court then had reviewed the PSI. They could have pointed out in the PSI. Now the plea negotiation was we're going to leave it up to the court to do the sentencing. That was the deal.
Well, then the state's not going to say a bad word then.
Right. Well, I'm just letting everybody know.
They kept their word.
So my main issue was, one, I'm not here to tell you that he can't give her 180 days. That's not what we're saying. But I got to be able to get ready for it. That's just fair for me as a lawyer, fair for Nancy, fair for everybody, just like they do. We are creatures of statute. Please make sure that he follows it. And when his decision did that, it was arbitrary. And at that point in time, then it allows you to resentence her. I don't ask you to remand it. I ask you to resentence her and holding those 7 days in advance if in the event she commits another offense or does another crime. You have the right to do that under Castlebrook Limited and In Re AJS. And it says that if a trial court abuses discretion, then the review would be de novo. And we'd ask that you apply them the proper law, which would kick out anything that he may have said to her daughter or anything that happened at the school. Thank you.
Please the court, Tom Morris again, and I still represent the state of Ohio, city of Wadsworth, prosecutor. I'll start kind of at the end and then work my way back. The prosecutor didn't say any bad word during sentencing, so we must assume it's true. One, there's an agreement that I'm staying out of sentencing, one, and two, I'm not even down there on sentencing. That's something for the judge. Typically, I don't go down there. If I was down there, it was because there was another case that I had to speak in, but I don't sit in council chambers. I don't. I'm not asked what the state's position is. I leave that completely up to the judge. So don't take my silence as agreement. Take my silence for what it was. Either I wasn't there or it wasn't my time to speak, or I chose not to speak at all. So I appreciate that we agree that 7 days is less than 180 days. It's first degree misdemeanor up to 180 days. Everyone's advised that. So the judge has discretion. What does the judge, when we're talking about statute, we're talking about 29, 29, 22. And we start off with the first part. The A section says that the judge can impose any sanction or combination of sanctions. Okay, they can do up to the 180 days. We know that. So how is the judge going to decide what an appropriate sentence is? Well, you have to look at the factors, and it says shall, that's the B, and there's a list of factors that the judge had. The judge had all those factors that were prepared on a pre-sentence investigation and were given to the judge, so he could review those factors. This isn't like the common police court where you have to justify which factors you're going by. If there is, the record is silent on it, there's a presumption, there's case law on this, that says that they have considered everything. All the information was in front of them. 3 prior OVIs were the basis for the 3 prior
And that's
alcohol.
going to be on the, I apologize for interrupting.
Not a problem. That should be in the PSI.
In the PSI, yeah, that's what I was going to ask you, thank you.
Typically they do that. I looked at the Leeds report while I was sitting over there, and that's where I came up with that. But that should be in the PSI, although I have not read the PSI either. Okay, so we have all these factors, and the judge's presumption that the judge used all those factors. He not only listened to the PSI, ordered the PSI, heard all the information, gave the defense counsel an opportunity to speak, to advise him of anything he needed to hear, let the client speak so he could hear anything that he needed to hear, and then he fashioned a remedy within the 180 days that he has discretion. Can he use anything else? Well, let's go to B, or to B2. B2 says in determining an appropriate sentence for a misdemeanor, in addition to complying with B1, the court may consider any other factor that is relevant to achieving the purpose and principles of sentencing set forth in 29, 29, 21. So those types of things were the need for changing the offender's behavior, the rehabilitation of the offender, the making restitution to the victim of the offense, to the victim or to the public. You have a lot of discretion when you're at the municipal court level of trying to fashion something that you think is fair. You're accountable to your voters, that your system of what you think is appropriate and what you think is too harsh and what you think is too lenient, you're answerable to the voters in front of you. You certainly have the option of reviewing those things. You're answerable to the voters. Judge McElvain has made it no secret that providing alcohol and a place for people to underage people to consume alcohol, to smoke marijuana, is not something that he is going to look favorably upon in the city of Wadsworth or its surrounding jurisdiction. He speaks to the high school and tells them, this is something that I don't look favorably upon, so when you're having your high school proms and you think this is a good idea, think again, this is not a good idea. past sentencings would indicate that it's consistent with this very sentencing. So he has a particular policy which he has and has every discretion in the world to have with regard to these types of situations. And he fashioned a remedy which he thought was appropriate, that was consistent with the factors he shall look at, and consistent with the other factors that he may resolve.
Counsel, the other side is arguing that, that those are factors they couldn't really prepare for them. The fact that the judge said, you know, I was at the Wattour school. I warned you should have been there, the daughter should have been there. I warned them that I wasn't gonna, like you just said, look kindly on this. And then indicated something to the effect that he was going to sentence her to 7 days, basically for a consequence for the girls.
I believe when I read the transcript that was properly filed, it was, I can't go to jail, I've got girls, I've got kids. His response was, they're going to use this as a lesson for their life. So I don't believe he was punishing them because his girls had heard this before, but he should have known it's a response to saying that this is a learning lesson for everybody here. Now, the judges give CLEs all the time. They tell their positions on certain offenses. This is what we do, this is what we don't do. Do I have a due process right as a lawyer that may practice in front of you to know all your preferences, to know how you deal with certain things differently than other courts may do?
But
I don't know that you have due process.
excuse me, but wouldn't you agree that the law requires you to handle each case individually?
Absolutely, and he did. He read the PSI to see if there's any factors which would deviate from what he wanted to do, or what he ultimately did. He let the defense counsel speak freely. He let the victim or the defendant speak freely. And based on that, he found it appropriate when he had a situation where she had 3 prior alcohol-related offenses, where he had a situation where there was a party where kids, underage kids, including the daughter, was smoking marijuana, had alcohol, had a sign that says beer before liquor, never sicker, had called from noise violations, and he said it was egregious.
And all that's in the record?
That was all in the record. It was in the PSI, it was in the police report. The police report is part of the record. Or it was incorporated by the PSI and the facts would be there. So I would suggest it's impossible I would suggest it's impossible for you to replace what we think is just and fair, as long as it's within the bounds of law, and replace our judgment with this judge. This is what his position is on underage. It's consistent with underage cases in the past, and this is very much a known policy that he's been having since he's been on the bench for 21 years. So no other questions? Thank you.
Attorney Dianas, you have just under 5 minutes.
Thank you. Real brief. What I think he did was not within the bounds of the law. I wouldn't have drove an hour here and an hour home. And I know 2929.21 because I cited on second line of assignment of error number 2. It sticks out. 2929.21 and 2929.22 allow us to prepare for certain things for sentencing. We're hearing now that he's going to scare everybody and sentence everybody in his community who does that. How could I even prepare for that then? There's no way that he should blanket sentence everybody based on what he tells little kids at a school. Now, if he tells Nancy, hey, I warned you last time you were here in court, and I told you that, and I can get a copy of that as a lawyer, then I can prepare for it. No problem. I'm not arguing that. But what he brought in was stuff outside of these factors. So if I would have hit run on this Commodore 64, what they're asking you doesn't exist. They're asking for this and any other stuff. You're not allowed. The court can consider how it may affect the public, how it may affect certain things. The other thing is, nowhere on the record is he saying there that this won't affect the local jails in our community, which in the Ohio Revised Code it says that the court should then make a finding that it won't affect the local community, and it's blah, 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 blah. He never did that. So then how is he then ordering her to 7 days? So we're asking that when you then review this de novo, because he didn't follow the law and the code, that you then put the 7 days in abeyance and she can continue working for Mike and her daughter can continue going to college. She doesn't need any more lessons. She's doing amazing. Thank you so much.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision which will be mailed to both sides, as well as posted to our website and then to the Supreme Court.
Thank you.
Thank you, gentlemen.